Supreme Court 2021. What a term! Good afternoon, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Yesterday, the United States Supreme Court closed out one of the most momentous terms in its history. The court corrected several profound errors in its past. When the court did that, it broke its slavish devotion to preserving error for the sake of preserving judicial infallibility. It also helped restore constitutional government. And we're going to talk about that, but we're also going to explore how this Supreme Court exposed some of the Constitution's weaknesses. Before I begin, I want to shout out to the sponsor of this channel, which is Conservative News and Views, link in the description. Be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of good merchandise there, including this recent edition. You read it? Marty, whatever happens, don't go to 2021. Now, you will no doubt recognize Marty McFly's DeLorean time machine. Well, back to the future. Now, the message is that 2021 was a horrible year. We know that. But as I hope to show, the Supreme Court's 2021 term was a fantastic term. And now, ladies and gentlemen, I'm going to tell you why. Simply put, the Supreme Court restored or helped restore the Constitution in an important sense. To understand why, we need to look back at two of its harshest critics from 2 centuries ago. The first of these was Judge Spencer Roane, who served on the Court of Appeals for Virginia from 1794 to 1822. The Supreme Court had just ruled McCulloch versus Maryland, 1819, link in the description, that the Second Bank of the United States need not pay any taxes to any state bank. In so ruling, Chief Justice John Marshall held that the federal government had an implied power to charter a bank. That power derived from the money coining power and the necessary and proper clause. That's Article 1, Section 8, Clause 18. Remember I talked 2 days ago about expressed, implied, and inherent powers of government. Well, by no accident, many constitutional scholars call Clause 18 the elastic clause because you can stretch it to justify anything. In other words, the Supreme Court read into the Constitution a banking power as an extension of a money coining power. This outraged Judge Roane, who decided that this was utterly without foundation. As he saw it, chartering a bank was neither necessary nor proper to the execution of the money coining power. Mints, and by that I mean the institution, not the candy, coin money. Banks borrow and lend money. Furthermore, by denying a state's power to tax the United States Bank, the Supreme Court revoked a reserve power of the states and thus violated the 10th Amendment. Judge Roane shared his outrage with Thomas Jefferson, and I have a link in the description to his letter. He enclosed several op-eds he had published in the Richmond Enquirer. He then asked for Mr. Jefferson's opinion. Well, Mr. Jefferson, a few days later, wrote back, and I have a link in the description to his letter of September 6, 1819. He agreed with Judge Roane completely. First, he complimented Judge Roane for espousing the true principles of the Revolution of 1800. Jefferson regarded his own election and the flip of Congress to the party he and Madison had started as every bit as revolutionary a change as was the American War for Independence. But that revolution had captured Congress and the presidency. It had not captured the Supreme Court. And now the Supreme Court, in Jefferson's view, was betraying his new revolution. I quote, "We find the judiciary and on every occasion still driving us to consolidation, unquote Thomas Jefferson. By consolidation, he meant the reduction of the states to mere districts of the higher level government with no sovereignty. But then Jefferson went further. Roane had written, apparently citing Madison in 1800, that, and again I quote, "The judiciary is the last resort in relation to the other departments of the government, but not in relation to the rights of the parties to the compact under which the judiciary is derived." Unquote Spencer Roane, quoting, as he thought, James Madison. That compact is the Constitution, but Jefferson saw at once what was wrong with that. The Supreme Court, being the body of last resort, dictated to Congress and the President about what was and wasn't constitutional. Nor had Congress used its impeachment power to check this. This led Jefferson to observe, and yet again I quote, oh, come on now, you know what I'm going to say because I've said it before. The Constitution, on this hypothesis, is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please. Unquote Thomas Jefferson. The further history of the Supreme Court would prove Thomas Jefferson correct in that assessment. Justice Clarence Thomas observed that in his concurrence in Dobbs versus Jackson Women's Health Organization. He identified a judicial Trojan horse called substantive due process, which had proved just as elastic as the elastic clause. Thomas blamed this for the decision in Dred Scott versus Sanford that would start a war between the states, and it also gave us Roe versus Wade in 1973. But that's not all. Magruder, publisher of American Government, has observed over many editions that the Supreme Court informally amends the Constitution through its decision-making. The history of the court includes many decisions, some since overruled, but many still in force, that infringe constitutional rights. Dred Scott versus Sanford and Plessy versus Ferguson are the two obvious examples, though neither one remains in force. The court corrected the second error, but it took a war to correct the first. Other decisions that still deserve our attention today include U.S. versus Miller, 1939, sustaining the National Firearms Act of 1934. Everson versus Board of Education of Ewing Township, 1947, forbidding government aid to any religious institution because it was religious. And in fact, I've talked about that before. You can play a video later on. McCulloch versus Board of Education of School District 71, 1948. That's the real school prayer case. Engel versus Vitale, 1962. That's the school prayer case of legend. The infamous Madeline Murray O'Hare liked to take credit for that, but she likely didn't deserve that credit. The credit, or the blame, goes to James G. Blaine, going back to 1875. Abington School District versus Shemp, 1963. Another explicit prohibition against Bible reading in class. Lemon versus Kurtzman, 1971, containing the anti-religious test bearing the name of the petitioner. Roe versus Wade, 1973. Well, you know what that is, so I won't explain it again. Let's see. Wallace versus Jeffries, 1985, forbidding silent prayer time. Lee versus Weissman, 1992. Forbidding baccalaureates or clergy-led prayers during graduation in government schools. And in the USA, a baccalaureate is a religious service for honoring graduates. Santa Fe Independent School District versus Doe, 1995. Essentially forbidding prayer on school playing fields. National Federation of Independent Business versus Sibelius, 2012. That's the Obamacare case. Obergefell versus Hodges, 2015. And you know what that one is, too. These precedents, more than any others, made hash of the First Amendment, especially its free exercise clause, and the Second and the 10th Amendments. They also represent an explicitly atheistic and authoritarian, if not totalitarian, jurisprudence with an obsession with socialism, hedonism, and death. But in the 2021 term, the Supreme Court has overruled many of these precedents and put at least one other in direct threat. Now, before we get into details, I want to shout out to another sponsor, BitNext. This is your replacement for Zoom, Slack, the Google G Suite, Microsoft Office 365, Dropbox, WeTransfer, and Chili Piper, among others. Unlike any of them, BitNext protects your content and conversations so well that even the administrators can't see it. So this is your channel for secure comms, conferencing, cloud storage, and file sharing. Best of all, everything is back-end. You don't even need client software. If you have a browser, you can use BitNext. Follow the link and give them a try. 28 days free of charge. You can't beat that with a stick. As I said, the Supreme Court knocked down many of those precedents I just listed and threatened others. To be specific, Roe v. Wade falls to Dobbs v. Jackson Women's Health Organization. About that case, the country got nearly 2 months warning, though I wouldn't recommend the method of that warning. Everson v. Board of Education of Ewing falls to Carson v. Macon. U.S. v. Miller doesn't quite fall to New York State Rifle and Pistol Association v. Bruin, but it does come under threat. Federal firearms regulation was not at issue, but state may issue licensing schemes that openly invited arbitrariness and caprice were. Lemon v. Kurtzman falls to Kennedy v. Bremerton School District. Now, in my view, this decision invites challenges to the McCulloch, Engel, Abington, Wallace, Lee, and Santa Fe precedents also. Had Coach Kennedy really pushed it, he could have knocked out Santa Fe as well as Lemon. I heard that. Some of you listening to me talk about knocking down the Establishment Clause precedents are already throwing things at your screen. He wants a theocracy. All right. Do I want this country to get back to being a Christian or at least a Judeo-Christian nation? Yes. I make no bones about that. Does that make me crazy? Well, hey. In the immortal words of James Stewart as Senator Jefferson Smith in Mr. Smith Goes to Washington, 1939, either I'm dead right or I'm crazy, and I feel fine. With that out of the way, in addition to every precedent I've just talked about, Clarence Thomas specifically, in his concurrence in Dobbs, invited re-examination of no fewer than 3 substantive due process precedents, and Obergefell versus Hodges is one of them. If any precedent will fall from revising out substantive due process, it's that one. Of the other SDP precedents, Roe has already fallen, and the other 3 precedents he mentioned will prove much harder to challenge, because maybe they just need better reasoning. In fact, I wouldn't want to revoke one of them. That's Loving versus Virginia. That was the miscegenation case. I've said it before, and I'll say it again. There is only one race, the human race. Virginia had a law on its books that denied that. The Loving case made it plain that there is only one race. You don't need substantive due process to tell you that. Just use your common sense. Besides all that, the Supreme Court threw up a breastwork against further compromise of separation of powers. In West Virginia versus Environmental Protection Agency, the court held that sweeping economic transformations need real old-fashioned law, not regulations. Executive agency regulation won't cut it. The court struck another blow to the bitter chagrin of 2 of its now current members. The third, Stephen G. Breyer, retired yesterday, but the court's newest member is probably just as put out about it as he was. The Supreme Court essentially held in West Virginia that America has not handed itself over to cadres of experts. Well, it's about time, because the history of science and medicine clearly shows that an expert remains an expert only until someone shows in ways none can deny that this expert's opinion defies common sense. How then can any government by expert function? But that's the hazard of our constitutional system. Too often the electorate, or a president and senate, will put people into positions of power they can't or shouldn't handle. And after that, rarely does anyone make a serious effort to remove them. And when some people do make such efforts, they make them in bad faith. We saw this with Andrew Johnson and with Donald Trump twice. Arguably with Richard M. Nixon and Bill Clinton, although those two deserved it, but for different reasons. But to Thomas Jefferson's point, we have never seen it with a justice of the Supreme Court. We have seen it with lower court judges, most notably with Al C. Hastings of the Southern District of Florida. He took $250,000 bribe from a drug defendant back when $250,000 was serious money. The Senate yanked him off the bench, but didn't disqualify him from holding further office of honor, trust, or profit under the United States. So, he ran for the House of Representatives, got in, and stayed in until the day he died. But I digress. Nevertheless, the Supreme Court went a long way to redeeming itself as an institution in the 2021 term. In fact, the biggest losing precedent is the one no one knows as such, because it isn't really a case. That precedent is stare decisis, the notion that the court must let a decision stand as decided, even in error. To observe that without exception is to treat Supreme Court opinions as if they were papal bulls and encyclicals, or decrees of the ancient Persian kings. See, for instance, the Ahasuerus decrees in the book of Esther. I see many precedents that deserve to fall, including all the precedents I listed in the first half of this video that remain in force and effect. And as long as they remain, this country has come back part of the way from being an explicitly atheistic country in which the government may invent a reason to deprive people of their right and the means of self-defense. Furthermore, the weeping and gnashing of teeth that we've heard from Sotomayor and Kagan JJ clearly shows the country can backslide. Alexander Hamilton extolled the virtues of an institution the members of which had lifetime appointments. See the Federalist and especially essays 78 through 81 inclusive. The vituperative attitudes of several members of Congress today show that Hamilton likely had something there. But the flip side is, we must be very careful whom we see appointed. And that in turn means being careful whom we tasked with making the appointments. More than that, if court, legislature, or executive tramples on your rights, fight for them. Coach Kennedy did not fight as hard as he might have, so he achieved lesser results. The pro-life movement did fight. Patiently at first, then with an all-out push, with the result you know. Gun owners have been fighting for a long time, but some of them need to realize how much harder they can fight. U.S. versus Miller went the way it did because Mr. Miller didn't fight for his rights. Now this is a true story. When the federal government was going to take Mr. Miller to the Supreme Court, Mr. Miller was nowhere to be found, so his lawyers couldn't plead his case. They told themselves, Supreme Court isn't going to let that National Firearms Act stand. They know it's unconstitutional. How wrong they were. I'm saying the Supreme Court decided that case by default. Today, anyone who declines to challenge an unjust law, executive action, or verdict loses by default. The same holds for those who will not challenge an erroneous precedent. The problem is that we all lose by such defaults. Coach Kennedy defaulted on some of his rights, as surely as Miller did, because although he showed up, he had already given away the store before he started. This term of court shows that the struggle to restore constitutional government in full is far from futile, nor is it over. We must continue the struggle. Links to the description of the article, to McCulloch versus Maryland, to the Spencer Roane and Thomas Jefferson letter exchange, and the conservative news and views. I have another link to the awesome online store and to BitNext, as I also mentioned. And if you like what you've heard, you can like this video. And on the end screen, I'm going to leave a subscribe link and also a link to a brand new playlist that I've created of all things Supreme Court. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.